Hello, today's session is really on contracts and contract type questions. But before I jump in right into contracts, contracts are obviously a big part of real estate, right? We have listing agreements, we have purchase agreements, we have lease agreements, we have the agreement between you and the broker. So a lot of contracts or agreements between two or more parties. Let's start first with my slide because I think that'll give us a good kind of starting point. So, in order to have a valid contract, we say we must have four basic elements in that formation of that contract. The first is legal capacity. You have to be 18 years or older and of sound mind. Now, what's an exception to this? Because the state exam loves to ask about exceptions. Well, an emancipated minor would be okay. So you know how you read about that little 14-year-old that's a Disney star and he's making millions and he's like, oh, my dad's spending all my money on in Vegas gambling or whatever their complaint is. That child may go to court and get emancipated, where the court will basically say you can act as if you were an adult when it comes to contract formation. So on a state exam, they may go, what's an exception to the 18-year-old requirement for legal capacity? An emancipated minor would be it. The second element of contract formation, mutual consent. This is the proverbial meeting of the minds, right? In order to have a contract, we have to agree to something, not just enough that we're both over 18. In our business, that meeting of the minds is best evidenced by an offer and acceptance. So, mutual consent is a meeting of the minds, an offer and acceptance. And we're going to talk about this later. However, if there's fraud or duress, that may make the contract voidable by the injured party. But so far, legal capacity, mutual consent. Third, lawful purpose. Whatever it is we are contracting for must be for something legal. You can't hire me. I watch a lot of that CNBC American Greed, and it's always, this couple got married and the wife bought life insurance, and then the guy was looking over the railing in the Bermuda and somehow he disappeared. So let's say you hired me to push that guy over and I got cold feet. And I said, hey, listen, I don't think I want to do that. And you then try to sue me and you say, hey, you cost me the $2 million life insurance policy as a result of you. I'm saying, well, no. So that wouldn't be an enforceable contract because it's not for a legal purpose. So we need legal capacity, 18 and older. We need mutual consent, meeting of the minds, an offer and acceptance. We need it to be for something lawful. And then there needs to be an exchange of sufficient consideration. And important to note, consideration isn't always money. It's anything of value to the parties. Maybe the two parties are, pet rock collectors, and that little pebble is very valuable to them. Okay, may not be to you and me, but so anything of value to the party. So we have legal capacity, mutual consent, offer acceptance, meeting of the minds, lawful purpose, and sufficient consideration. Sufficient consideration. Now, if it's missing one of those, especially mutual consent or lawful purpose, then we say it's void, it's invalid. It's invalid. However, if it has all four of those elements, but there was fraud or duress, the victim of the fraud or duress might choose to void the contract or continue forward because that's my prerogative. That's their prerogative. So there's a difference between a contract being void, meaning it's not a contract at all, versus, hey, it's a contract. However, one of the parties could void it due to cause. Now, let's get some definition for fraud. So fraud, we might say, is an intentional lie for gain, right? You saying, you were late because there was a traffic, but you were late because, I don't know what you were doing. That's a white lie. Fraud is an intentional lie for gain, right? And duress is undue influence. Well, from who? Well, from someone that maybe is in a position of authority over you, or someone who you've hired to be an agent on your behalf, um, gives you this undue influence to do something that maybe you didn't want to do. So if you suffered from fraud or duress, we say that contract then might be voidable by the injured party. So there's a difference between void and voidable. Now we have this statute of frauds. That's kind of a common law concept, a statute, if you will, that says not all contracts have to be in writing. However, certain contracts, if you're going to enforce your rights, then must be in writing. And how does that pertain to us? Well, real estate contracts fall under the statute of frauds requirement that they be in writing in order to be enforceable. So a listing agreement, a purchase agreement, a lease for 1 year or more, right? More than 1 year, or a employment agreement between a salesperson and a broker must be in writing in order to be enforceable. However, there's a little exception, and sometimes the state exam gets tricky. So they may say, all contracts related to real estate need to be in writing, except what's the exception? And the exception is a lease for 1 year or less could be verbal and still be enforceable. Now you may ask, well, why are they making that an exception? Well, partly it falls because that tends to protect tenants more that maybe weren't aware to get something in writing, and it tends to make it difficult for a landlord to terminate a lease that was made verbal, that was for a year or less. So if you see a question that says, what's the exception to that statute of frauds requirement for real estate agreements? A lease for 1 year or less. Now, people always ask me, well, how would you prove it? How would you prove it? Have you ever been sued? Have you ever been in a lawsuit? It's called discovery, testimony, maybe text message. That's why lawsuits cost money, because it's not that easy. I give you a pack of gum, I'm probably going to put it in writing. So that this doesn't mean you don't have to put a lease for 1 year or less in writing. It just means if you happen to not put a lease of 1 year or less in writing, it could still be enforceable. Okay, so we have 4 elements of contract formation. Now, I kind of want to talk about some certain scenarios that hopefully will make more sense now that we talked about this a little bit. The first is lawsuits that result from a breach of contract. So if you've been in an agreement with maybe a listing, a purchase, a lease, then what you sue for, most people, so a question might say, what's the most common legal remedy someone pursues when they feel there's been a breach of contract? And the answer would be damages. And then that takes us to, well, how do you define damages? Well, damages might be defined as an amount of money to make you whole, to put you back together before this breach occurred. So what's the most common legal remedy once you do have enforceable agreement is damages. The party would probably sue for damages, an amount of money to make you whole. But there's another concept I want to make sure we understand called, you might also sue not for damages, but for something called specific performance. Specific performance. And this falls under the concept that real estate is considered so unique in some cases, meaning there's no other dirt in-house or dirt by itself anywhere in the world the same as that X and Y location, right? So this kind of falls under this uniqueness of real estate, that while there might be a similar home and there might be a similar plot of land, there isn't exactly that property. So in some cases, you maybe are not suing for an amount of money to make you whole, i.e. damages. What you may be suing for is the person to do what they said they were going to do, to continue with the purchase. Specific performance. So what's the difference between damages and specific performance? Well, damages is an amount of money to make you whole. Specific performance is, no, I want you to do what you said you were going to do. Now, In our legal system, most of the time, the court's probably going to want you to decide on some damages, probably. But when no other remedy will do other than you doing what you said you were going to do, contractually, you said you were going to sell me the property, I performed, then you might sue for specific performance. Okay. Now let's talk about listing agreements. Again, when you hear listing agreement, what you should think of is, oh, I got hired to sell someone's house, right? You're going to be a realtor and you're going to get hired to sell. Well, what makes sure they pay you that 5, 6, 7% of the $1 million you sold? Because that's a lot of money, right? 50, 60, $70,000 you might have earned by getting them to hire you to sell their home. Well, that written listing agreement is what makes that promise for a promise enforceable. So a listing agreement is between a broker and the seller, which we will refer to as the principal. So when I say a listing agreement, I want you to think of, oh, that's the agreement between the broker and the seller, the principal. Well, what do we discuss in a listing agreement? Well, the two basic promises in a listing agreement are, I'll work hard to try to find a ready, willing, and able buyer. And the seller says, well, if you do, then I'll pay you whatever we agreed to in commission. And again, rule number one, period, if you were in my agent training program, we'd say rule number one is everything's negotiable in life. Everything's negotiable unless prohibited by law. In some cases, we can't negotiate it away or change what the law says. However, most things are negotiable. So how much commission can you charge when you're listing a home? Whatever you think you're worth and whatever the seller is willing to pay. That's a negotiable between a broker and the seller. Now, when I say broker, I'm really meaning the salesperson, but really you're binding the broker. So the salesperson really doesn't act as the broker. The broker is the one that's creating the agency relationship with the client. But since you work for the broker, you're kind of a sub-agent for the broker. And the broker may never even meet this client. You did all the work. We still say that the broker contractually has the agreement with the seller, which is an important distinction, because if you see a state exam question that says a salesperson secures a 90-day listing with a seller, 30 days later, that salesperson leaves the office. Who owns the listing? And the answer is the original broker, because the contract is between the broker and the seller. Even though you did all the work, that broker probably never even met the client. That's just the way it is. And when we talk about agency relationship in another session, I also want to emphasize why it's the broker that creates the agency relationship, not the salesperson. And that'll become important when we talk about dual agency and buyer agency and seller agency. But listing agreement, a contract between the broker and the seller, what basically is it? It's a promise for a promise. It's, I will work hard to find a ready, will, and able buyer. The seller says, and I'll agree to X amount of compensation if you do. So that's an example of a promise for a promise. So we can further describe that type of a contract as a bilateral contract. A bilateral contract, a promise for a promise, a promise for a promise. So who are the two parties in a listing agreement? The broker and the seller. Don't say buyer, because we don't even know who the buyer is at this point, right? Next contract type concept. The purchase agreement, the purchase agreement. Who are the two parties in a purchase agreement? That's right, the buyer and the seller, not the brokers, the buyer and the seller. So the buyer makes an offer and the seller accepts that offer. And now they have a promise for a promise, right? Hey, I'll pay you $1 million. I'll give you legal title to that house. Promise for a promise. The purchase agreement between buyer and seller. And it's also an example of a bilateral contract, bilateral contract. But let's go a little deeper into the purchase agreement. When is it officially enforceable? Well, remember we said real estate contracts must be in writing in order to be enforceable. So if you're sitting at an open house, and this happens, well, we haven't been able to sit open houses right now, as you know, because of COVID. However, if you're sitting in an open house sometime in the future, and someone walks in and says, "Oh, I'll give you $500,000 for that house." And the buyer and the seller says, "I'll take it." And then the next day you call them up, say, "Great. When do you want to open escrow?" And one of the parties says, "Oh no, I'm backing out of the deal." Well, the other party couldn't hold them to it because it was verbal. It's not enforceable. So real estate purchase agreements need to be in writing in order to be enforceable. And that offer to the seller has to be binding in this way. The person makes an offer, the seller can either accept it exactly as presented and then send the written acceptance back to the buyer. Once the buyer receives the written acceptance, we say it's enforceable, or they could reject it. "Oh, I'm insulted. It's so low." That would terminate it. Or they could counter, right? The buyer makes an offer. The seller says, "Oh, this looks great. However, I want 100,000 more." So they're basically terminating the buyer's offer, replacing it with their own and saying, "Now it's up to you to decide whether you'll accept, reject, or counter that offer." So when do we have an enforceable purchase agreement? When both parties have agreed to all the terms and conditions as presented and communicated that acceptance to each other, right? Which means another way to think about it is, when would it not be enforceable? Let's say you wrote an offer, the seller said, "Fantastic." They sign it, but before the acceptance in writing gets sent back to you, you get hit by a bus. Well, that means you never received that acceptance, so that wouldn't be enforceable onto your heirs, if you will. Another way to see it is, you make an offer, the seller is thinking about it, and you rescind the offer before they have signed acceptance and send it back to you, then there would be no contract. When would there be a contract? You send an offer, the seller accepts as presented, communicates that acceptance back to you in writing. It's physically in your hands, or in theory, right? You got the email, you got the fax, you got receipt of confirmation in writing of acceptance. We now say you have an enforceable purchase agreement. Now, leases, right? Leases are interesting because we have a landlord and a tenant. The landlord basically makes the promise that, "I'll give you the right of possession," right? The right to be there. And the tenant says, "I'm going to give you X amount of money or compensation in exchange for the right to be there for a certain amount of time." So we can say a lease is also a bilateral contract, a promise for a promise. And again, as we said earlier, if it's for 1 year or less, it could be verbal. But if it's for more than 1 year, it would have to be in writing if you want to enforce your rights. I don't want to jump around here, but I don't want to miss some of the things I wanted to mention here. Now back to listing agreement. So a listing agreement, we said, between the broker and the seller or the principal. If the broker dies, that would terminate the listing, So whoever replaces the broker at that office would have to sign new listing agreements with whoever had those listings, if they're willing to even continue. So death of a broker terminates a listing agreement, Okay. Now, there's a couple of confusing, or they sound confusing at the beginning, questions on binding listing agreements. So the first one, let's set it up. Husband and wife, right? Community property, they have a home to sell. The agent meets with one of them, and only one of them signs the listing agreement. So let's say in this case, the wife signs the listing agreement. The husband maybe doesn't even know she wants to sell. Maybe it's going to be a surprise. And the question might be, now that agent finds a ready, willing, and able buyer. So he performs on his promise. Are they bound to pay a commission? And the answer actually is yes. So that wife, or let's say the husband might have signed a listing agreement, could be held responsible for owing a commission because they can bind themselves to an obligation like that. The same way you don't need your spouse's permission to get in credit card debt. You don't need your spouse's permission to owe for that steak dinner you buy. The same kind of concept. Now, that was if they might be responsible for a commission owed by agreeing to a listing agreement and then the agent, the broker delivering on that promise. Different scenario, purchase agreement, purchase agreement. Again, husband, wife, community property, only one of them signs. Are they obligated to sell or transfer the property? No. No, in order for that agreement to be binding, both parties would have to have signed and agreed to the purchase agreement. So the distinction is one party could bind themselves to owing a commission on a listing for sure without the other party signing. On a purchase agreement, both parties on title would have to sign that they're an agreement of this sale. So there is that distinction. So if you have a question like that, make sure you see the difference. Now, again, we're talking test questions. On a practical level, what happens? A broker is going to pull something called a preliminary title report. I don't want to go into title insurance right now, but basically most sales require title insurance as a result of financing or prudent decision by the buyer. And the title insurance company basically ensures that at the time of the sale, the buyer's getting what we call marketable title. So really title insurance is insurance. They're saying, hey, listen, we're going to protect you against certain things that you should know before you buy that house. And when you get title, we're going to say you had marketable title at the time. And if something comes up that we should have known about, you can put in a claim for that. So that's title insurance, but that'll be another session. So with that title insurance policy, very often they're going to produce something called a preliminary title report, which is this report that once you're a salesperson working for a broker, you can get this for free from the title insurance company. They'll say, hey, here's everything we know about the house that's recorded. And you could look there and see, well, who's on title, who owns the home. So when you go get the listing, you're like, well, it looks here like there's two people on title. I need them both to sign the listing agreement. So you make sure you don't have any issues. But the setup of the question was only one of the spouses signs the listing agreement. The broker performs. Could that person still be responsible for the commission? The answer is yes. Only one party signs the purchase agreement. The agent performs, brings a ready, willing, and able buyer. There's a contractual agreement. Would that other spouse be forced to go along with the sale? And the answer is no, because that purchase agreement would have required both owners to sign that purchase agreement. But again, in practical business, how do we not have those problems all the time? Because we're afforded this preliminary title report. If you request it, that'll help you verify who's on title. And it's good practice because that preliminary title report will tell you a lot of things. It'll tell you who's on title. It'll tell you what liens are against the home that are recorded. It'll give you a lot of good information that you can clear up with the home seller before you get into a purchase agreement. That one big important thing, and again, I don't want to go too deep into it today because we're talking contract questions, is perhaps the seller is in default and the bank may foreclose before you can close escrow. That kind of would be important to know. Or perhaps the seller owes more money than the home is worth. So you want to make sure they understand that if you bring a ready, willing, and able buyer for the agreed upon sales price, that they may have to come up with more money to close the deal. So that preliminary title report is very, very important to review. I always like to review it before I go on the listing, because also sometimes maybe a kid will be representing their parents, and the truth is they're not in any position to bind their parents because their parents are the ones that are on title. So the preliminary title report is an important thing. We'll talk about that in another session. So listing agreement between broker and seller, the principal. If a broker dies, that cancels the listing agreement. One party, if they're married, could bind the seller, or the not, you wouldn't be binding your spouse, but you would still be responsible yourself for the commission owed if the broker delivers a ready, willing, and able buyer. So if you get a question like that, yes, the broker could still earn a commission even if only one party signed the listing agreement. On a purchase agreement, it does require both. And then again, a purchase is between a buyer and a seller. We can describe these type of agreements, listing agreements, purchase agreements, lease agreements, as bilateral contracts, a promise for a promise. A contract, though, needs 4 elements, right? We need to have legal capacity, mutual consideration, a meeting of the minds, offer and acceptance. It needs to be for a lawful purpose, and it needs to have sufficient consideration. If a contract's missing 1, 2, 3, or 4 of those elements, then we say it's void, it's invalid, it's not a contract from the beginning. If it has all 4 elements, however, there was fraud or duress, it could be voidable by the injured party, Okay, that's it for today. See you on the next one.